The Committee on Education and Labor will come to order for the purposes of holding a hearing this morning on protecting U.S. and guest workers, the recruitment and employment of temporary foreign labor. And I want to thank our witnesses who are here today, and I'm going to begin with an opening statement and then recognize Mr. McKeon. Welcome to today's hearing on recruitment and employment of temporary foreign labor. Hundreds of thousands of guest workers come to the United States each year under existing programs, and immigration legislation now pending in the Congress would further expand these sources of temporary foreign labor. As a country and a Congress, the debate reforms to our nation's immigration system, it is critical that we pay particular attention to the treatment of guest workers and how well our current guest worker programs work. Examining guest worker programs and proposals for new programs raises a lot of questions. One question is whether or not and to what extent temporary foreign labor is actually needed. That is, are we accurately measuring our labor needs? Are U.S. workers truly unavailable to fill the jobs, and is temporary foreign labor the right way to fill those needs? Another question is this: if we have a new guest worker program, do those programs include adequate protections for both guest workers and U.S. workers? While they are in this country, guest workers should receive basic labor protections and adequate legal safeguards. Denying or failing to enforce basic rights for guest workers who are here is harmful both to U.S. workers and the overall U.S. economy. Yet, as we've seen in various reports and news accounts, our current guest worker programs are sorely lacking in meaningful labor protections. Problems with these programs occur from the very start of the process. In foreign countries where guest workers are first recruited in exchange for thousands of dollars in fees, unscrupulous labor recruiters lure workers to the United States by promising them good jobs and a better life. Many of these workers who live in poverty in their home countries sell their land or take out high-interest loans or borrow from their neighbors so they can afford the recruiters' fees. Guest workers come to this country with the hope of providing their families with a better life, but in far too many cases they arrive here only to find that they were cruelly deceived. They earn unlivable wages for extremely difficult jobs to which they have never agreed. They find themselves unable to repay their deep debts to their recruiters. Sadly, those are the least of their worries. Guest workers often endure sweatshop conditions and backbreaking work and inhumanely long hours. They are forced to work through illness and injury, sometimes with only 1 day of rest per week. Employers frequently withhold wages from guest workers, and in some cases they automatically deduct the majority of the workers' weekly pay to cover room and board. Meanwhile, the housing that is provided guest workers is often severely substandard with no electricity, hot water, doors, or windows. There are cases where guest workers suffer physical violence at the hands of their employers and are threatened if they should try to leave. Consequently, they are left with little or no money, no voice, and quite often more in debt. Unable to pay off the debt manufactured by the recruiters and their employers, the workers are trapped by fear. It may seem impossible that I could be describing the working conditions in the United States in 2007, but I am not exaggerating. These deplorable practices not only undermine living standards, they ruin lives. In their worst form, these practices constitute the closest thing we have in this country to modern-day slavery or indentured servitude. These practices drive down wages and working conditions for American workers, too, who must now compete to work alongside workers who are treated shamefully. Before we invite any more guest workers or create a new program to this country, we must fix the serious flaws in the current system. First and foremost, we need to ensure that if U.S. employers are permitted to hire guest workers or fill job openings, it is only when there are absolutely no American workers or workers here with legal status available and willing to fill these jobs. Then we should only allow guest workers, then we should allow new guest workers. We must provide with adequate labor rights and protections. If and when the abuses of these rights occur, we must enforce the law and hold employers and recruiters accountable. I have introduced legislation, the Indentured Servitude Abolition Act of 2007, that would help put a stop to these practices. Among these things, the bill would hold recruiters and employers responsible for the promises that they make to prospective employees and for their treatment as guest workers. By preventing U.S. employers from exploiting cheap foreign labor, we will not only end these serious human rights violations, but we will also help fight against a race to the bottom in wages and benefits for all workers in this country. Dealing with labor recruiters, however, is just one part of the solution. We need strong, meaningful protection for all workers, and we need to ensure that those protections are vigorously enforced. This morning's hearing is critically important to the work that we're doing to reform the nation's immigration laws. And we have an incredibly distinguished panel of witnesses with us today, and I'm pleased to welcome them again to the committee.